Really important when you have legal needs to have a specialist. And I'm really lucky today because I was looking for somebody to refer business to in New York. And one of my favorite attorneys and past guest on our Probate Weekly Meet a Circuit and recommend strongly Matt Abrams out of New Jersey in New York as a specialist in probate and trust administration and estate planning. And Matt joins us today from the Hackensack River in the background from Newark, New Jersey. Matt, thank you for joining us today.
My pleasure. Thank you for having me.
So how do you say your personal specialty in the practice of law is? What areas, how would you describe it?
I would describe it everything trust and estates. That's from planning, from the beginnings of preparation of documents, advice on estate and inheritance tax, on gift taxes, things like that, all the way through to a point where people grow older, they pass, and then those estate documents and trust documents need to be administered. And where necessary, where they need to be litigated, whether it's to interpret them or actually where there's a fight between an executor and beneficiaries or trustees and beneficiaries.
So most commonly as real estate agents, we get involved, unfortunately, when people, after the cows got out of the barn and we're trying to put it back in through a probate or trust litigation. So let's talk a little bit about probate administration in New Jersey and New York. Now I'm in California, though we have a national following. How would you describe the process of probate administration in New Jersey and New York to your knowledge? Is it something that requires attorneys best served, complicated matters should have attorneys? How would you describe kind of the process of probate in New Jersey and New York?
So I would say the difference sort of spanning the Hudson River is significant. New Jersey is a bit more client friendly, meaning people can go in self-represented, can generally get through the process. The forms are substantially more simple. The kinds of jurisdictional requirements and notices that have to go out are much easier to get out. New York is wildly different. New York, I think, could not be more attorney focused. It's jargon, it's actual practical rules, and how one actually finally gets to the point of having a will admitted to probate or having authority over a person's estate if they die without a will. It takes a lot more in New York. And in New Jersey, things sort of are more efficient. And then you send out a notice saying, good news, the will was admitted to probate. If you have any issues, you have a set time frame in order to raise them. In New York, you essentially have to clear all of those issues before the court will actually issue the decree. In a nice sense, when it's done, it's done. But on the other hand, that's where you hear about delays in getting a will admitted to probate over the course of, a year, 2 years, 3 years in New York. Right. You don't hear that so much in New Jersey.
So if somebody was to pass away and have a will, what's a common time period before they'd be authorized to sell the property in New Jersey and then in New York? Obviously, there's a shortest time period and then the common time period, and then there's the uncommon case is obviously forever. But what's the most common? Or if you're advising a client, how long would it take them, or should they schedule if somebody passes before they can sell a property?
So generally, I would say in the range of month to 2 months. It's a little different between the two, as I say. In New Jersey, I would say 2 months or so is the normal period of time, at the end of which you got letters testamentary or letters of administration, and you can go ahead and sell the property. There are some inheritance tax related things you have to do in New Jersey, but that's sort of another story. New York, you will almost never have a will actually admitted to probate in that shorter period of time. But as a matter of course, sort of general practice, we ask the court for preliminary letters testamentary. That allows the people to, the executor, collect assets, sell property, take care of business, essentially. The only thing it doesn't allow them to do is to distribute the assets. But when sometimes you just need to, clear the house off the books, that's not a bad thing. At least you can get ahead. You can capture a good market. You can, essentially get the right buyer locked in at the right time.
There's a misnomer that a estate plan or trust will avoid litigation. Certainly, it will reduce the likelihood of litigation and delays and such. So let's talk about New York and New Jersey, and that's in California. So about New York and New Jersey, how valuable is it to have those plans ahead of time to effectuate transfers and to avoid costly and time-consuming litigation?
I think it's always valuable to have them from the point of view of efficiency. Having to pay quarter after quarter of property taxes or carry a mortgage for longer than anybody really should, to nobody's benefit except the bank. Those things are substantially reduced, not always eliminated to that point, by having planning in place. The one step that I know California has the same kind of approach. I think a lot of planners in California do, as they do in New York and New Jersey, Florida, almost everywhere, is where possible to avoid probate altogether with a revocable trust in place of a will, in order to try and basically make it the only stumbling block. Basically, it's getting a death certificate in place, and that plus the trust, will clearly authorize to any third party that the nominated trustee or the successor trustee has the ability to sell the property, and that is sort of the height of good planning. Not just having a will, not just having a will that spells out what you want, but actually having some thought behind the most efficient way when the time comes to get that authority or to skip the court entirely, essentially.
It seems like more and more now I get phone calls from real estate agents, colleagues of mine, who have a client who, mom or dad passed away, bad sibling is, has the trust, won't tell me what's in the trust, isn't doing what he's supposed to do, won't sell the house because he's living in it. And that's kind of the precursor for, litigation and conflict and challenges. So if somebody is an heir and maybe they're not the successor trustee, but they believe they have substantial interest, does it make sense to hire an attorney at that point? And what is the cost to do something like that?
It certainly can. I think a lot of the time, people will let you go as far as you could possibly go, or they will run as rampant as they can until somebody stops them. And sometimes it's that they don't know any better. Sometimes it's that they do know better and they just want to take advantage of the situation. And right. It's reduction back to being 5 or 6 or 7 years old and saying, "Make me," So what I would say is, at that point, generally we try and gauge the situation appropriately, start things off collegially, formally, but otherwise, essentially ask for information. If they don't provide the information, then you have a predicate for asking the courts to force them to provide information. You can also have situations where, especially if they are in a fiduciary capacity, the administrator, the executor, the personal representative, the trustee, whatever the title is, where you can essentially get the court to remove them if they are not acting in compliance with their duties, their duty of care, their duty of loyalty. So if they say, "I don't feel like moving and you can't make me move," well, the court may be able to make them move, especially if they're taking advantage of their position. I think the costs of doing that vary on the situation. Most firms like ours does require some sort of an advance. And so to some extent, it's tough. Sometimes we know that people are only getting the benefit of money when they inherit it. So to force the fiduciary's hand to give them the money so that they can pay a lawyer, so that they can sue them, is not really an option, realistically. But, generally we ask for, say, 8 to 10 hours worth of billable hour time at a rate that I generally try and gauge. I have my street rates, we all do, but try and come up with a reasonable number to make sure that we are covered as to the first generally fairly intense couple of weeks to a month. And then otherwise, take the client's lead. If the client says, "I didn't realize this was going to get so expensive so quickly, I'd like to back out. I'll just try and, tough it out with my sibling or my whatever. I'll figure it out." Okay. We've done our best. If they see the benefit of ramping up the intensity, then we also know that they've had the ability to pay the bill so far. And, while law is a calling, it's also a business you have to follow.
Right.
So, yeah.
Right. That's the challenge. I don't think people appreciate how expensive it is. It's not just the attorney you're hiring, but all the costs involved in litigation, discovery costs, deposition costs,
Yeah.
And the paperwork, the filing of the forms. And so you have to really vet through. And I think also, in my experience, people will call everybody and get everybody's advice, but an attorney. and then they decide what their strategy is before they actually to figure out, well, what really can you do? And the answer is you might be forced to make a concession because the costs are so high and your case may or may not be as clear as you think it is. So do you often consult with customers and kind of vet out the case, or how would one come to you? Do you take referrals only from attorneys, or do you have consumers who are families in squabbles give you a call and talk to you about it? What's the process look like for you typically?
A lot of the time, the referrals come from other professionals. Sometimes it's by word of mouth from a client that I helped through something, and a friend mentions to them they're going through something similar. They say, you should talk to Matt Abrams.
Yeah.
We don't, take a consultation fee. We track our time so that if we're retained, time goes on the bill. I try and be reasonable with the amount of time I give to someone before I ask them officially to retain me or not. I'm never going to pressure somebody to retain me, but after a certain point, if they're asking me to review 100 pages worth of documents and they've got 40 different questions, each with their own subparts, I have to draw a line reasonably. But otherwise, I try and make the impression as early as possible that I have taken people through the process. I have real empathy and not just a knowledge of the law. I'll try and find the most efficient ways, the cheapest, although that's a relative term, through to the desired result. And if I make my case that I've won their trust over the course of the first half an hour to an hour, and they retain me, then we know we're good. Otherwise, essentially, we don't set up a matter to take $500 or $600 to do a consultation for an hour. On top of which, that rarely does it for people. I think the reality is, with a complicated enough situation, I'm talking with them for an hour, maybe a little less, and giving them the lay of the land as negatively as it can be, as objectively, clear as it also can be. The law is the law, but the actual application of it takes a lot longer, costs a lot more, to your point. And so try and basically explain what they're in for, but that there is, a resolution to be had. It just may take a little while. It'll take longer than they like. It always does. And that at some point they may settle and essentially say, well, I'd rather have 60 cents on the dollar than none or all of it, but 3 or 4 years from now. So sometimes that's how things end up. Sorry, I think I lost the audio here.
No, that was me. I'm sorry. I muted myself because I have a little bit of a cough, so I muted myself so I wouldn't cough. What I was going to say is, to the real estate agents watching this, I do try to vet leads before I contact attorneys or have customers do, just because so often we in message boards see, hey, I need an attorney in New York. Well, what do you need them to do? Oh, litigation. Well, let's talk about what, and then you find out what's not really probate. It's really some sort of a lot line adjustment or real estate litigation or some other unrelated matter. And then I try to get the documents together. So when I send it to the attorney as a referral, I've already pulled down the property profiles and the documents they say they have, just to speed up the process so that the attorney can look at the matter and make an assessment more efficiently and hopefully make the decision to move forward with the client, or if not waste their time or money. And I think it's really important that we not just refer business, but we refer it effectively for referral partners. And that's one of the things I know Mina's kind of taught me in working with attorneys to be effective as well. So I wanted to ask you, in New Jersey and New York, is there a part of the probate code that requires court approval? In California, we have 2 types of authority. We call full authority, which you have to have notices, but otherwise you can sell on your own. We have limited authority, which requires the court to approve a sale. There's a very strict, detailed process for court approval. In New York and New Jersey, do you have similar court approval processes, or are the sales pretty much handled by the administrator or the executor?
So in both states, if you have full, letters testamentary, if you've got real authority, you don't really have any stopping point for the most part where you have to have the court's approval. There are times, let's see, in New York, for instance, if the property has been specifically bequeathed, if it's been, to my son, Bill Gross, my home at 123 Mulberry Street. If it's specifically bequeathed and the executor says, I'd love to, but we need that money to pay estate tax. Sorry, this person was, land rich, cash poor. And then if that legatee, that person receiving the bequest, doesn't agree that it should be sold for whatever reason, the executor does have to go to court to obtain the court's authorization to sell that property, notwithstanding the bequest. There's also in administration, in the absence of a will, a lot of the counties in New York, certainly this is the same in New Jersey, they require a bond be filed for the administrator to assure that the administrator won't just essentially collect all the money, liquidate the land, and take the money from that, and then split to some other country or whatever. When you get authority and you have to file a bond, sometimes the court will allow you to qualify for a smaller bond amount because there's a charge to that premium, and then require you to come back and be specifically authorized to sell the piece of property, in part so that they can make sure, the court can make sure that the legatee, the distributees are getting a fair price objectively, that there was some thought that went into it, but also so that if needed, they can increase the bond to now the amount of cash essentially that will be on hand. I've done that with people in New York County and in Brooklyn, Kings County, in Queens as well. So, it's more along those lines. It's not necessarily that with a certain kind of authority you can't sell. My example before of preliminary letters testamentary, you can sell, without anybody's permission. The same rules apply. Specific bequests, there may be a bond, things like that. But it's not exactly like California, for better or worse.
In terms of real estate agents looking to build their business in this area, I strongly recommend them to pick one county and to master that county, to both look at the probate court's online resources, as well as go to the county courthouse. And I know some courthouses are wide open again, others are virtually all virtual today. But as a general rule, would that be good advice for somebody looking to build their business in real estate? Are there resources? Is going to the county process productive, would you imagine, to learn about the procedures and processes?
I would say in New Jersey, the clerks are going to be a lot more friendly, or at least they have comparatively less stress maybe on them. They've still have plenty to do. New York, I would not expect to walk into the courthouse and start picking the brain of a clerk in the probate department or the administration department and get any real attention. There may be somebody, but otherwise, outside of the city, also in New York, I think you find that the surrogates court and the clerks are maybe a little more friendly. Nassau County and Suffolk County out on Long Island, Westchester and further north. In terms of resources, I've never really found one, and I haven't taken the time to write one to really give people a guide. I more so offer to talk to them, including if they're not going to be clients, if they just want to understand a little bit better the lay of the land as a real estate agent. So I normally have the discussion version rather than the check out this book or this pamphlet, something like that. There are, I should say, New York, more so than New Jersey. New York has uniform forms for probate versus accountings versus administrations versus X, Y, and Z. And they have checklists that the court clerks themselves go through and make sure that when some proceeding has been filed, whatever they might need has been checked off. They know what they're doing otherwise, but you could always look at a checklist like that and maybe better understand what a client selling a property out of an estate, for instance, should need to get together before, if they can, before they engage an attorney. Sometimes there are things that we would prepare that no client will ever, or no layperson would ever, find online or find a reliable form of it online. But that's what I would say. Those checklists are not bad.
Matt, you've been a wealth of information we go on, but I appreciate your time as valuable, as well as I have some things I have to jump off on. But for people who are interested in more information and or have an appropriate case referral, we'll put your contact information. You are with Sills Cummis and Gross. To no knowledge of mine, we did our check as far as attorneys always say they check for conflicts of interest. So I did my check for conflict of interest. I'm not aware of any connections family-wise to your law firm. I'm not going to walk in and say I'm the named partner or anything like that. But anyhow, there's your information's online, and we'll put that in the description down below. Mark, friend of our program, of Mina Sirkin, who recommended you strongly, serving New Jersey and New York. Thank you so much for your time today. I really appreciate the chance to chat with you.
Thank you. Thank you. This was great. Thank you.